This meeting is being recorded.
Here we go. Hello, inventors and entrepreneurs. My name is Andrew Krause. I'm one of the co-founders here at Inventor Groups of America. Wave your hands in front of the screen if you're new here to Inventor Groups of America, or type into the chat, I'm new. You can click on the chat button at the bottom. We'd love to welcome you. IGA was founded in 2017 by Stephen Key and myself to teach individuals how to best commercialize their product ideas, as well as strengthen and support inventor groups across the nation. We have a directory of local and regional inventor groups on our website, whom we meet with every month. And if you're located near one, we highly encourage you to join. In a little bit, I don't know, maybe about 10 minutes or so, I'm going to drop a link into the chat with a map that has all the inventor groups across the country, so you can attend a local inventor group in your city and state. We would love to hear your name and what state or country you're from, so go on over right now, open up the chat box, and let us know. Please do not disclose anything that is confidential and is already publicly available. This meeting is being recorded and will be harnessed on our website and our YouTube channel very, very soon. If you have any questions for the speakers, please type them in the chat as they come to you. We'll choose a few questions to answer at the end of the presentation, maybe even a few during, but don't hesitate. Just go ahead and type them in as they come to you, okay? Now I'm going to turn things over to Madeline Keys, who's going to introduce our very special guest from the Patent Office.
Hi, Inventors Groups of America. It's a pleasure to be with you here tonight. My name is Madeline Key, and I am currently the Marketing Director for IGA. I'm very excited to welcome our two very special guests from the USPTO. A couple of years ago, we had the pleasure of hosting several patent trial and appeal board judges for an educational webinar. They enjoyed speaking with our group so much and the opportunity to educate inventors that they asked us to come back. There are additional resources that they've been working on. We know that there are so many questions about the patenting process. It's always a pleasure to have such highly intelligent and caring people with us on tonight. And I just want to echo also what Andrew said. All questions are welcome. Please let us know what's on your mind. And without further ado, I'd like to introduce you to Judge Stacey G. White. She is a lead administrative patent judge with the U.S. Patent and Trademark Office. She received a Bachelor of Science in Computer Science from Michigan State University and a Master's of Science from DePaul in Human-Computer Interaction. She received her JD magna cum laude from the University of Illinois College of Law, where she served as editor-in-chief. She clerked for the Honorable Barbara M.G. Lynn for the U.S. District Court of the Northern District of Texas, and then practiced patent and trademark litigation in Dallas. Prior to law school, she was a software engineer for Motorola. I'm also very excited to have us here with tonight, John Schneider. He is an administrative patent judge who was appointed to the Patent Trial and Appeal Board in 2016. Before that, he served as an associate at the law firm Arnold, White & Durkee, PC, and at another law firm named Fish & Neve. He went on to serve as senior counsel at ExxonMobil Chemical Company prior to returning to private practice. He also has experience with Acacia Research Group and Promethean IP Consulting. He earned a law degree from Fordham University and a Bachelor's of Science in Biology from Lehigh. Before we get started with your presentation, which looks excellent, I'd just like to hear a little bit about what motivated you each to join the USPTO and work with and for inventors.
Well, I don't mind going first. Thank you again for inviting us out here tonight. We're really excited to come out here and speak with you and share this information with everybody in this group tonight. As you mentioned, my name is Stacey White. I've been with the PTO now about 10 years. And before that, I was a software engineer. So I was one of those folks working on not just the actual computer systems, but I was actually doing some field work in the lab, doing all the dusty work, flipping chips off of boards. I did that for several years before I went to law school, and then worked as a lawyer for a while, and then decided that I wanted to do something different. I wanted to really be a part of the public service and to come to the government and try and do something to help the patent system and to help people with their innovations and inventions. And I've been doing it for now about 10 years.
Wonderful.
Thank you.
John, what about you?
Thank you, Madeline. I went to law school after I got out of the Army, so that was a different career path. But having worked in a lot of different law firms and in corporations, even though my degree is biology, I actually got to work with a lot of different technologies. And I've also worked with big corporations, but I've worked with solo inventors. And it's much like Stacey, I realized it was time to come back to the system and help give something back to the community in a way. I mean, not all our decisions are precedential, but even the slightest one we write gives some guidance either to the examiner or to the inventors who come before us. And so it helps educate the public, and being part of this education program to me is very important, and I really get a lot out of it, and I think it's worth your while. So that's why I came to the board. I say I've been to the board about 6 years, and hopefully let them stay me as long as I can until they carry me out the door, I think.
Nice. And to give all of you a little bit more context for how this presentation came about, specifically, John and Stacey do a lot of work on the appeals process. And, when we're meeting with them, we're saying, okay, but, how many inventors are really being affected by this? And they told us very clearly, while it isn't a huge number that end up filing an appeal, they do work with inventors who represent themselves. And so they understand how useful it can be to have more information about the appeals process. So we decided to back it up even a little bit further, because for many years, I've heard my dad talk about how when he filed his first patent applications, he was sure the USPTO was against him. They were issuing rejections. They didn't want him to get his patent issued. And it was this acrimonious sort of fight. Today, he understands that's not quite accurate. And when we had Director Vidal on in July, she mentioned something similar, which was there's specifically women are known to abandon a patent application after receiving a rejection at a much higher rate than men. And that might be because they don't realize there are additional opportunities to keep moving that application forward. So that's really the spirit of this webinar, is we want to hear all of your questions about what to expect after that patent application. And John and Stacey have also prepared a great presentation, which will start kicking off now. But again, don't hesitate to share your questions. And if anything comes up during, we'll try to address them there. We'll also save about at least 10 minutes at the end, if not more, for questions.
Great.
Sweet.
John, were you going to share your screen?
Yeah, I'm going to switch over to that now.
Okay,
So
great.
Here we go.
I love the topic. What to expect after you file a patent application.
Yeah.
I love it.
Okay. So it shows I'm sharing. Can you see the screen? I'm sorry.
Yes, it looks beautiful.
All right. So part of what this is really put together originally to talk about resources that the Patent Office, and particularly what we call PTAB, which is the Patent Trial and Appeal Board, we'll also sometimes call it the board, have developed to help inventors. Primarily, we were focused on the solo inventor who didn't have a law firm behind him, but we realize now that a lot of these features also help even those of you who have counsel and people represented. So we're going to talk a lot about some of the different resources. But to start, as Madeline said, we're going to try to help you understand where we fit in and where all these different assets can be useful to you in the process. So first, we're going to talk about the patent life cycle and where we're talking about. First of all, you're going to you'll thought of something that you want to in patent. You've created an invention. So you learn about patents, and you hopefully go to, and we're going to talk about a little bit, one of the patent and trademark resource centers that are available around the country, and learn something about what patents are, how to apply for them. Hopefully got a name of an attorney if you can, or if you can't afford one, hopefully learn about two of the programs or three of the programs we're going to talk about today that'll help you with that. Then either you or your attorney will prepare an application. You'll file it with the office. You'll have to pay some fees, but as a small inventor, you're entitled to use either the small entity status or maybe even the micro entity status, which is a significant reduction in the fees. I'm sorry, but that's how we get paid. You got to pay your fees. So if you want us to look at it, you got to pay it. One thing I have to say, the Patent Office, which you may not know, the Patent Office is a self-supporting agency of the government. We don't use tax dollars. We're strictly funded by our fees. So that's why our fees are what they are. Now, then you go into the examination process, and we'll talk a little bit more. This is the give and take with the examiner, where he's going to make sure you meet the criteria to get a patent. and then hopefully the patent issues and you get into the maintenance and hopefully licensing or otherwise exploiting your patent. So what do we have here? The patenting and appeal process. What we developed here is a somewhat simplified timeline of what happens. So this is in that box about the examination process, but we can step back a little bit about that. But you
This
develop
doesn't
your
look
invention,
simple
you
at
learn
all,
about
John.
patenting, you filed your application. It can
This
be a
looks
lot too much
complicated.
complex, believe me.
Fair
So
enough. Fair enough.
you file your application. It goes to an examiner who is a person with technical training, usually has a background in whatever technology you're working with. And he also has some rudimentary legal training about what's the criteria to get a patent. And he'll look at it and he'll make a search through the references he's aware of. There's the databases that he has available to him that he'll search for. And he'll come up with what we call a rejection. Because basically he's finding that there is some reason, and we'll talk about some of them in a minute, that your application doesn't qualify for a patent.
Mhm.
It's usually what he's focusing on mostly are the claims, and that's what defines what your invention is. He's usually taking some exception to the wording of those claims, or that there's something that matches something that's already been done, or it's obvious in light of somebody else has done. So you'll get this letter from the patent office saying rejection, office action, rejection. You have a chance to respond, either by yourself or through your attorney, present technical legal arguments. You can make changes to your claims, make amendments is the term we call. And then you send it back in the office, the examiner looks at it. Maybe he buys your arguments, maybe he doesn't. The trick is, if it's the second bite, they're going to call it after that, they're going to call it a final rejection. That doesn't mean you're done. And that's sort of what Madeline was talking to. Just because it says it's final doesn't mean it's final. You have several options when you get that rejection. You can appeal to the board. If you think you've got good grounds, that's usually sort of a last resort. You can file a request for continued examination, RCE. Basically, we're asking you to pay some more fees to spend some more time with the examiner. Or you can just give up. Hopefully you don't do that yet. What we'd like to encourage you to do would be to try to continue to work with the examiner. In addition to sending papers into him, you can also sit down with the examiner and either on the phone or by video, or if you can, even in person, and talk with them about it. We call that an interview. And if you're represented by counsel, obviously he needs to be there too, but it's a very effective tool for building a rapport with the examiner and helping to explain to him what your invention is all about. One of the things you can do, if you've got a physical model here, I'll show you one. This is from a patent that was issued in the 1870s. It's a patent model. You can bring a physical embodiment of your invention into the examiner and show them how it works. Take it apart, show them the inside. Sorry, I'm trying to get in front of the camera here. All the different parts to it. You can show them what makes your thing different and try to sit down with him and explain to him what your invention is, what's the gee whiz, and why it's different than what Schmedlap made 10 years ago.
And John, is that quite
And
often
John-
on a video chat these days? Is that
No,
quite
sorry,
often?
you can do it by video. Yes, you can. The examiners have video capacity. And also, if you don't have video capacity yourself, if you are near one of our offices, there are rooms with video capability available that you can use to do that. You can also, if the examiner is local to you, and for example, we have an office here in Dallas. So let's say you were here in North Texas and you wanted to come here to Dallas, and the examiner is also working here in Dallas. You can try to meet with him personally here. Not everybody's in DC. I mean, 80% of the patent office now is working remote. So chances are he's sitting home someplace. But if you can convince him to come into the regional office, he or she, should be more willing to come in and speak with you. But certainly video is very, very best way to do it if you can't otherwise do it. I know we're all spread all over the country. So they're encouraged to do these things, to meet with the inventors and talk to them about it. And you'll get a chance to summarize. Sorry.
I was just going to add in there that
summarize. Go ahead, Chase. I'm sorry.
I was going to say, as far as where our offices are, it's Dallas, Denver, San Jose, Detroit, and Alexandria. So any of those locations, if you can get to either one, any of them, they have a room in there where you can access the equipment to do a video conference, and it has equipment that will allow you to show and demonstrate any models that you have as well. So even if you don't have the ability to do it at your home, if you can get to any of those locations, you can make arrangements to do an interview from there.
Well, while we're on this slide, can I ask a question that really confuses new inventors? And I think it is partially on the patent attorneys don't explain this to inventors, that it's extremely common. I'd like both of you guys, Stacey and John, to comment on this. When they get their first office action back from the patent office, they almost always they reject all the claims. Can you talk about the fact that that is common, and also the fact that I have so many patent attorneys that don't explain that to inventors, and then the inventor freaks out? And so why is that? And what should people know about that?
It is rare to get an acceptance on your first office action. That is not the typical situation. And when that does happen, it's usually in a circumstance where this is a continuing prosecution, where you've had several other similar patent applications and you and the examiner have gotten into some sort of rhythm. But for somebody coming up with their first patent application and they have not done any prior work with this examiner, I would be shocked if you got a first office action allowance. That just doesn't happen very often. And I think you should go into it thinking the first thing they're going to do is tell me no. But no is not necessarily your final answer.
Right.
Yeah, that's
I will tell
a
you,
great
in
question, Andrew.
almost 40 years of practice, I've only had one application where I got a claims allowed on the first filing, first action. And I sat down and said, maybe I didn't draft this claim broadly enough. So it made me worry the fact that I didn't get some rejection. So usually it's, you'll go in trying to claim as broadly as you can and use the examination process as sort of a give and take to narrow it down to something that covers what your invention really is a good solid patent, less likely to be challenged, or if it is challenged, to survive. So the active examination process, the more active it is, the more likely your patent is going to be a strong one when it issues. So don't look at it as a problem. It's actually to your benefit to go through that process and work with the examiner to make sure that the claims are as rock solid as they can be.
Thank you. Thank you.
So
Yeah,
so again,
that's a really important perspective. No, I just want to double down on that. I think the way a former patent examiner once expressed it to us, it kind of related to prior art, is that you can be helpful with that examiner in not being shy and supplying more prior art, because that allows them to not then necessarily have to find these other things that you haven't made them aware of. And then you're talking about that, but you're saying, here is what this is, or here's the other evidence, and actually strengthen that for your point of difference. Because to me, that's what that negotiation sounds like, is we're getting clearer about what is the bounds of what I own and have invented versus what already exists. We're getting some great questions already. So if it's all right, I think we'll ask a couple. Darren Austin said, at what point is it appropriate to request a meeting with the examiner? After the first response, or is this something that's typically happens after a rejection?
You can ask for an interview almost at any time once it gets assigned to an examiner. And as Judge White mentioned, especially if you're going to file several patents or continue to work in the same area, having the interview with the examiner helps you develop a rapport with that examiner and can help you later on in your process. I mean, when I was with Exxon, I worked in a particular technology area, and most of my applications were sent to a particular examiner, and we just sort of had a rhythm down. We could sit down, and he would call me and say, oh, if you do this, I'll allow your claims, or I could call him and talk to him about things. You just develop that rapport with the examiner. I also was able to do that for a client out on the West Coast there who now has a new intraocular lens product on the market. And again, we worked with the same examiner often on that and developed a rapport with him. And once we got that, the examination of the other applications, it's flowed much more easily.
Mm. So maybe you're establishing some mutual respect, yeah, I think rapport is a good way of looking at that. I think recognizing that examiner's humanity and your shared humanness of getting on the same team as opposed to being on different ones. That makes a lot of sense. Here's another good question from Gary. I have a friend who filed a patent, but it was rejected. I think that rejection could have been overcome. He gave up. It's been a few years. Does he have a chance to resurrect it, or is there a time frame that he can no longer do that?
Unfortunately,
Well,
there's a time frame, but it's variable based on a lot of different criteria. Normally, you've got about and Judge White, correct me if I'm wrong, usually we're looking at about a year to be able to revive it. Although there are exceptions to that. If it wasn't what they deserve, they call a willful abandonment. But you'd have to ask the commissioner, the director of the patent office, to make an exception, revive it. There's usually fees that have to be paid in connection with that. And also, I remember correctly, you have to file a response to the last office action that was there. But if it's been a few years, the likelihood of reviving it is probably very small.
Okay.
I won't say absolutely no, but that was something you'd have to refer to a specific attorney. But I just know in general, the rules will say, you've got to do it promptly, and you've got to be the term they like to use is diligent in trying to get once you discover the abandonment, that you try to fix it. But if it sounds like in that case, if he decided I wasn't going to do anything with it, that makes the case probably a lot harder.
Got it.
the thing to keep in mind with the patent office, for everything you do, there's a certain amount of time that you get to do it. And there's typically an opportunity to pay a fee and get a little bit more time, but the times are important, and you can have legal repercussions for missing your dates and deadlines. But it's usually a certain amount of time you're given and a certain amount of time you can buy.
Yeah, it's a lot more dramatic when you go outside the U.S.
Oh, interesting. Okay, great info. Well, thank you for letting us interrupt you. Please,
No,
I know there's
no
a lot
problem.
more slides to get to.
That's okay. We'll make sure we hit the important ones. So we'll go back to our slide here. And so we've come through the whole process here. And so, but sometimes you reach a point in your negotiations with the examiner where you think you're right, and you think the examiner's not reading the references properly, or he's misapplying the law. And we just had a very interesting seminar where we had two inventors from Australia that represented themselves before the board. And they said, the reason we went to the board was we tried working with them. We just got that, it wasn't acrimonious, but we just couldn't convince them of the merits of our invention. So that's the time you might want to consider appealing the case to the board. And we'll talk about that process next year. But before we do that, this is the type of things that, sorry, go ahead. You have a question?
No,
These are the things that the examiner is looking at in deciding whether or not to allow your claims. There are, as you can see, are 6 criteria here. First one is it proper subject matter. There are some things that you are not allowed to patent, metal processes, works of nature, things along those lines. But otherwise, as long as it's a composition of matter or something, a mechanical device, a process, a method, those things can be patented. But it has to be new. It has to be something that nobody else has ever made before. And it doesn't matter if it's described in a patent. It can be something that's been sold. It could be something that's described in an article. As I said, a lot of work I do now is in biotech. So a lot of the things we find are articles or journal articles that people have published, or it might be something sitting under a shelf there that somebody else has made before. It also can't be obvious. And that's sometimes a little hard concept to understand, because it allows us to bring in bits and pieces of knowledge from all over the place and combine it together. And there's this mythical person called a person of ordinary skill in the art, and someone working in the technology area who reads everything and knows about it all and can put together pieces of things. But we can't just do a mix match. There has to be some other things go in there. The last 3 deal more with the wording of either your patent application or your patent claims. They have to be clear as to what is you're claiming. Has to be some connection between what's described in the claim and what you put in your general disclosure, which we call the specification. And there has to be, it has to teach somebody how to make that invention. That's the term we use is pre quo quo. That's the deal you have. Will it give you this exclusivity for 20 years from the filing date of your application, maybe a few years longer? But in return for doing that, you have to educate the rest of the world how to make and use your invention. So that's what we have to make sure you've done in that specification. These are usually the grounds for what the rejection. You may also get something that's called an objection. And that's usually because it doesn't meet one of the regulatory criteria of it, and the drawing's not being the proper style and what have you. We don't deal with those generally. Those have to be handled through a separate process. And if you want to go back and look at one of our webinars, we call it Inventor Hour, we talk about the distinction between rejections and objections and how to deal with objections. So this is what we're talking about here are rejections, and it's based upon one of these six, one or more of these six criteria. Normally in an office action, the subject matter, if there is one, the objection will be first. Then there will be the rejections for how the patent is written, the claims are written, and then there'll be what we call the art rejections, which are the novelty and obviousness rejections. So that's the general structure of a rejection that you'll get. Here we go. So what does the board fit in? This is try to show you generally where we are within the structure in the patent office. Patent office has two sides to it, obviously the trademark side and the patent side. And there are the two examining groups. That's at the bottom here. There's the trademark examining attorneys who will review your trademarks, registrations to be sure it's proper. And then we have the patent examiners. And they again review, examine, hopefully grant your patents. Both organizations have appeal boards to it. There is the Trademark Trial and Appeal Board, which again hears appeals from rejected trademark applications, but also challenges to existing trademarks. And then we come over to the PTAB, which is our organization, and we again hear appeals from examiners and also the challenges under what we call AIA proceedings, which you've probably heard of as IPRs or PGRs. To be honest with you, that we do a lot of both. And we just got our statistics for the fiscal year, and we had over 6,000 ex parte appeals decisions issued last year. And of those, approximately 20% were small entities or micro entities. So you guys are actually a significant part of our work. I don't think we realized it until we saw the numbers. It's really is. And now in the small entities, we do include some of the universities as well. But even if you take them out, that's still a significant number. So sure. It is an option out there. You know, we're willing to work with you. And that's why we've developed these tools to help you understand and work your way through the system and hopefully be successful when you come before us. So next is the appeal process. We'll sort of go through this quickly. When you decide you're going to challenge the examiner and come to the board, you have to give them notice. It's a written paper you file. You then file an appeal brief, and we'll talk a little bit more about that later. Examiner gets to respond. You can file a reply to the examiner's answer. At the same time, you have to pay the fee for the appeal. Sorry, it's there. You can also request an oral hearing before us. We do still have hearings, although most of our hearings are done virtually in a format, some like we have right now. But you can, if you're near one of our offices, request to show up in person. And if there's a judge available, he or she will be there to listen to you. And then we issue a decision, and then hopefully it's yay or nay, but then there's processing after that goes on. Usually the application goes back to the examiner. You can try to, if we've agreed with you, generally your case will issue. If we disagreed with you, you'll still have an opportunity to continue to work on that. We've had people come to the board multiple times on the same application before they finally get what they deserve, which is a good solid patent. But now we're going to talk about some of the resources that we put together and already exist within the patent office. One is something that you want to look at when you're first getting started in this, and it's what's called the Patent and Trademark Resource Centers. What this really is it actually goes back to 1870s. We started with patent libraries. Because they wanted people to be able to see the patents and research them and look at them. Congress dictated that we would start putting copies of patents in public libraries around the country. New York City Library is one of the first ones to have that, and it's a really fantastic place to go see. But now it's grown to also include trademark work, and also we are trained librarians. They're trained by the Patent Office how to do searches, teach you how to do searches using the databases available there to help you find attorneys in your area and learn about intellectual property in general. There are, we'll go to the next slide, approximately 80 of them around the country. You'll see some of these, there'll be more than one in the area. They're either public libraries or university libraries, sometimes other types of libraries. I think the only state that doesn't seem to have one, and maybe you guys can tell me, why does not Oregon not have one? But I've been to the one in New York City when I was in law school doing research for an article I wrote about, and it's really a great resource, especially when you're first getting started on this. And if you haven't had a chance to use it, I would encourage you to look at it and to learn more about the technology in the areas you're working and what other people have done. Because reading other people's patents also gives you an idea of how to write your own patent and how your claim should be structured. So this is a fantastic tool. There is what's called the Inventors Assistance Center at the PTO. This is probably a great sort of a help desk. It's manned by retired patent examiners. You can call this number. It's an 800 number. It'll show you on the next screen, and it'll give you general information about the patenting process, where to file the papers. It's more the nuts and bolts of the application process. They can't give you legal advice, but they can help you understand. Our manual regulations is about that thick, and the patent examining guide is about that thick if you had it in print copy. So there's a lot there. These people know the rules, and they can help you navigate through the rules, at least as far as the nuts and bolts of your application.
And I'm going to give you guys a little plug here. I tell inventors all the time, don't be surprised if you call and they're super, super helpful. When you call 800 number, the local number, if you're outside the US. And my spiel to folks is the patent office is not supported with tax dollars, they're supported with your patent dollars. So they're actually, whatever negative connotations you have or thoughts you have about government agencies, they do a much better job. And I think that's partially why I think you guys do a great job. And I tell people all the time, don't be surprised, they'll help the heck out of you. I had one student that this woman was not tech savvy at all. Some person from your organization at the Inventor Assistance Center spent 2 hours with her on the phone. I mean, that's getting kind of ridiculous. And she's like, oh my God, I can't believe they put up with me, And so I'm not exaggerating, guys. They're super, super helpful. I've experienced that with our students.
Yeah. And I know it's a long URL there for the website, but if you just type in Inventors Assistance Center in our search corner on our website, it'll also take you to that same page and give you the numbers here. Same thing for any of the things we're talking about. If you use the broad term and search for it, you'll find what you're looking for. We'll try to give it here, and Madeline and the others will have copies of this presentation that can make it available to you.
Sure.
Now we're going to talk about what we call the pro bono programs, and there are 2 pro bono programs plus a law school clinic program we're going to talk about. The first one is a patent pro bono program. These are for underrepresented inventors where you can't afford the cost of a patent attorney or a patent agent. And it's a regional program, as you can see here. There are a couple of dozen groups around the country. They are certified by the Patent Office to provide assistance. There are attorneys who are volunteers. They are licensed and registered attorneys. It's available for independent inventors and small businesses, and they'll help you draft and file your patent application. This is a separate program. They only get you to the point where either you've got a final rejection and you think you have to appeal. They don't necessarily take you to appeal, and the board but Stacey's going to talk to you about a program where we do have lawyers who will help you with that. And then, but each of these different organizations have their own criteria as to who qualifies for their pro bono work. As I say, they are sponsored and by the patent office, but we don't control how they limit access or provide access to people and who they help. Generally, we're talking about small business entities or solo inventors for these organizations. The chances are you can find one working in your area. And again, here's the website for it. And it's very simple. This one's probably one of our simple ones, pto.gov/patent pro bono.
Does everybody know what pro bono means? Some people may not. You want to tell them, Stacey?
It's free legal services. So pro bono just means that the lawyers that have agreed to take work on pro bono have agreed to represent you without taking any fees for their services. Now, you still will have to deal with USPTO fees, but you will not have to deal with legal fees. And anybody that's been through the process knows that that can be a pretty big lift if you have to pay the legal fees as well.
Right.
So our next program we've got is the PTAB pro bono program, and this is Stacey was one of the driving forces for this, so I'm going to let her speak to
John, can we go back to the other slide with the patent pro bono program?
Sure.
What are I know you're going to share the qualifications for this, but what are the qualifications for the patent pro bono program?
Well, he did mention that they differ from group to group, that there's no one set of eligibility requirements. So I think
generally there will be an income limit, or if it's a small business, it has to meet the SBA small business criteria.
But if let's say you're earning $250,000 a year, you're not going to qualify.
No.
Yeah. Okay.
I would say no.
Make that
I would say it's usually a some multiple of the poverty
Federal
levels.
poverty.
I don't know if your program is. So it's usually
Yes.
tied to the federal poverty program as for the individuals. But as I say, this program also helps small businesses. And so I'm not sure where the cutoff would be on the business, but it's probably, again, it applies the federal SBA definition of what a small business is. We tend to borrow each other's definitions. So again, you can find more about the program on the website and the actual criteria. But again, it's generally set by each of these regional organizations.
I can tell you that for the majority.
Sorry. That's
for
going
the
to be true
majority
for
of
the law school program as well. Sorry. We're both too
we are
anxious
crashing
here.
into
Sorry.
each other today.
they're excited. They're so excited. That's good.
For the majority of the organizations that we work with through the patent pro bono program, the limit is 300% of federal poverty. So that increases based on the number of people in your household. If you are a single person in 2022, 300% of federal poverty is about $41,000. But if you have 2 people in your household, 3 people in your household, what have you, that number goes up. That's the number for the majority, but not all of the programs. Some of the programs have different standards. There's some programs that have different standards for veterans. There are some programs that have lower standards because their particular state has a different standard for pro bono. So you need to go to the specific program and see what their criteria are, because the patent pro bono program is sort of a patchwork of 32 different programs. So there can be some differences depending on where you're going as far as what their eligibility criteria are and what you need to do to get help through the program.
Thank you. Thank you.
It's great info.
So now we'll go over to the patent pro bono, PTAB, pro bono program, which, as I say, Stacey helped put together.
Okay. Well, the PTAB pro bono program is a separate program from the patent pro bono program. So these are 2 different free legal services programs. This one right now is focused on helping people through ex parte appeals, but later we're going to be expanding to what we call AIA trials, and those are the proceedings for people that already have issued patents that are being brought back to the office for challenges. We thought that it was important to start a PTAB pro bono program because the proceedings before the PTAB are more legal proceedings in nature than what you're dealing with the examiner. With the examiner, it's a back and forth and you're talking about mostly technical issues, some legal issues, but it's a different sort of process than what you're dealing with. Here you've got judges, you've got briefing you have to write. We're looking for legal arguments. We're looking at things like cases you've cited, if you cited cases. It can be a different type of process, and it can be, for someone who's not familiar with these sorts of things, a little bit difficult to navigate. So we've come up with a number of tools to help people with the ex parte appeals process. And that's what it's called when you appeal your patent application. It's called an ex parte appeal. Lawyers, we have this bad habit of sprinkling Latin all over the place. In the end, it's just a way for you to have this conversation with the judges, but it's a different type of conversation than what you were having with the examiners. So the PTAB pro bono program is a way to provide some legal assistance for people of limited financial means who are going through the process. But there are some things that we've created to go along with the PTAB pro bono program that may be of use to people, even if they have counsel. So if we could go to the next slide. So unlike the patent pro bono program, with the PTAB pro bono program, we only have one national organization that is checking everybody's eligibility. So we have one set of national criteria for the PTAB pro bono program. And that's what you see on the screen right now. So you have to be domiciled or living in the United States, household income of 300% of poverty, which, as I mentioned, was for 2022, close to $41,000 for a single person household. And the number goes up depending on the number of people you have in your household. You need to be a micro entity. Now, micro entity is a term that we've mentioned a couple times through this presentation, but a micro entity is sort of the smallest entity in our scheme of determining fees. So a micro entity is someone who hasn't filed more than 4 previous patent applications, has some limited financial resources, and because of that, you can get a 75% reduction on USPTO fees for most things. There's a few things that are not hit with that particular reduction. But as you can imagine, a 75% fee reduction can be huge. So it's one of the things that you need to look to see if you are eligible for, even if you're not in the appeals process. It's something you should look at early on when you're filing your application, because if you can qualify to be a micro entity, you can save quite a bit of money on your USPTO fees. The other thing that we want to...
Go ahead. There is a form on your website. Somebody can fill out a little spreadsheet where they can fill it out and figure out if they're microentity status. And the vast majority of people I know that file a provisional patent for $75 as opposed to $150 as a microentity, I don't know how many of them actually fill out the form and figure it out, or they just select microentity. But there is a form. My guess is they can just search for it on the patent office site, right? I haven't done it myself recently. But...
Yes, indeed.
Okay.
While we're on this topic of microentity, Sonia asked, can you only have filed 4 provisional patent applications or 4 non-provisional patent applications? Or are they, does it matter which? Are they weighted in different ways?
Great question.
That is actually a good question. I would need to look at that to see what the rule is, whether it's 4 provisional or 4 full applications. I can double check that during the presentation and circle back with that info. That's something I could look up and let you know.
Perfect.
But that is something that you should look into if you think you might be eligible because of the cost reduction. If you could be a microentity, it can be quite helpful. So the next point I was going to say is timing. Time is important here. If you want to be a part of the PTAB pro bono program, you need to file the application for assistance within 1 month of the date of the office action that you want to appeal. We have that timing restriction in there because we want you to be in a position where the PTAB Bar Association can do its work, trying to match you up and find you an attorney, and there still be some time left on the term for you to get your notice of appeal out and to get your appeal process going. Because depending on our availability, it's not guaranteed that you file the application and we're automatically going to have an attorney for you. In some circumstances, we won't be able to match you, and we just don't want somebody to be in a bad situation because they waited around for us and their time expired and now they don't have the options that they would have otherwise had. So to keep you from being in that situation, we've put a restriction on it. And so the only people that can apply for this program are people that are applying within 1 month of the date of the office action. So time is of the essence. If you think you want to use the program, go ahead and apply. And I'll talk to you about how to apply in just a moment. The other thing that's there that I think is something that's useful for both people going through the PTAB pro bono program and people just looking at appeals in general, trying to figure out whether it's for them, is that we have 2 videos online. They're on our website right now. One describes what the PTAB pro bono program is, how you apply, all that good information. The other one gives you some details on the ex parte appeal process. And it steps through what the stages are and when you can expect sort of things to happen. I think that's some good information for you, whether or not you go through our program, just to see a good rundown of what's in the ex parte appeal process so you know what to expect. And it'll also help you if you have counsel to have some better questions to ask your lawyer, because the more you know about the process, the more you know about what's going on, the better position you're in to have a good conversation with your lawyer and have it quickly, because we all know that they charge by the minute. So that can be helpful too. The final thing you need to have is an appealable rejection. As Judge Schneider mentioned earlier, things can either be objected to by an examiner or they can be rejected. If it's objected to, that's not really a substance. That is a real thing, but it's not necessarily based on the substance of your claims. Your appealable rejections are going to be the things that he was going through as far as the 101 on subject matter or the 102 on novelty. Things like that are going to be your appealable rejections. And those are the things you can bring to the PTAB. So you need to have something that can be appealed. Everything else that's an objection goes through a petitions process that doesn't come to us. So if you're going to be in this program, you need to have an appealable rejection. Okay, next slide, please. So in case you're wondering who these people are that would be helping you out if you go through the program, these are licensed patent practitioners. So it's not just somebody that says, hey, patents are interesting. These are people with in good standing that have passed an examination before the Patent and Trademark Office regarding their knowledge of patent law and patent procedures. They have to have had some experience in the technology that you're working with and the type of proceeding that you want to go forward with in front of the patent office. They have a type of insurance called malpractice insurance, which in the unlikely event something bad happens, they're insured on that. They have to carry that. That's not provided through the program, but every one of our volunteers has to have that. And as part of the pro bono program, of course, they have to agree to take no fees for their services. So your lawyer, your patent agent, they are not getting paid for the work they're doing. They're just doing it to sort of do a good thing for the community. Now, these lawyers and patent agents will provide a representation agreement, and that agreement will step through what the scope of the things are that they're going to provide for you. What are they actually going to do? When do their services start and when do they end? Because our program is limited. The PTAB pro bono program takes you up through getting a decision from the board, the Patent Trial and Appeal Board, but it doesn't take you on after that. So if you get a lawyer through the PTAB pro bono program, that person is not necessarily going to be representing you if you have some sort of commercialization, if you have some contracts you need to negotiate related to it. That would be a separate representation outside of the PTAB pro bono program. All right, next slide. So as I mentioned, one of the things that's different between this program and the patent pro bono program is that we have a single nationwide clearinghouse. So the PTAB Bar Association is an association of lawyers that practice a lot of the time, some of them exclusively in front of us, and they have taken up as sort of a community service thing that they're doing the work involved with reviewing applications from inventors, taking in information from volunteer attorneys, and doing the matching between the volunteer attorneys and the clients that would like to get some free representation. The PTAB Bar Association is its own organization. It sets its own policies and procedures, but we're telling you right now what their procedures are as far as their current eligibility standards and everything. But they're the ones that are making the matching decisions. It's not happening by your judges. It's not happening by your examiners. It's a separate set of people that are doing that work.
Can we get some clarity on how likely it is? I think John had stated there's about 6,000 folks go through PTAB per year, he said, and 20% of those are independent inventors. So that's only 1,200 people of all, like, how many, I don't know how many patents are filed each year, end up in PTAB. So it's very unlikely they're going to end up in PTAB, but it is possible. So it's great to have this as a resource to help with the finances to take care of it.
Yeah, it's an option that they have. We're just,
Yeah,
we're not trying to encourage you to come to us. I think we're busy enough, but we just want you to understand this has actually been PTAB's mission since the first board was created in 1861. And the IPRs and PGRs that you hear about a lot in the press and the chat groups and everything else, one is fairly new and is only a portion of what we do. Our real meat and potatoes has been and still is hearing these ex parte appeals from different inventors, different inventive entities to help them hopefully overcome an examiner's rejection. So that's really what we're trying to educate this side of it. And these are some of the tools that we've tried to develop to help all inventors, whether they're bearing them by themselves or even with counsel, to do a better job and hopefully be more successful when they come before us. So that's what we're trying to talk about today. And these are obviously the tools we have for those who don't have the financial resources. And there's one more that we're going to talk about right now. But here's the web address for the PTAB Pro Bono. Again, it's very simple, PTAB Pro Bono. But now we're talking about the law school IP clinic. And actually, I'm going to put a plug in here. We have a monthly webinar program that the PTAB sponsors called Inventor Hour. And it'll be tomorrow at 1 o'clock Eastern time. I know it's going to be early for you guys on the West Coast. I apologize. But we talk about different topics and we invite people to come in. Stephen Key came in and spoke to us. It's very good, very, very excellent interview. Tomorrow, we're going to have the director and the supervising attorney from a law school clinic program come and give a presentation tomorrow and be interviewed by one of our judges who actually was a student in that program many years ago before he became a licensed attorney. But this, like the patent pro bono program, is a way for people with limited resources to get assistance in drafting and filing patent applications and prosecuting them. These are students, law school students, but being supervised by licensed attorneys who volunteer their time. Again, there are a number of law schools throughout the country, and as you can see here, some do specifically patent work, some only do trademark work, and some do both. But there are spread all over the country. We actually have 4 here in Texas, 3 of which are in the Dallas area. We have several out on the West Coast and a large concentration in the Northeast. Like the PTAB Pro Bono program, each school sets its criteria for who they'll help. So I can't tell you, but you can probably learn more tomorrow if you come and listen to our program. Another plug there makes my boss happy. But we've got that going on. Again, you can find more of the law schools that are involved in the program. And I'm sorry, big long URL here. And if you type in law school clinic into the PTO website, you can find it. And I'll tell you where the law schools are that are willing to have these programs. To be honest with you, I wish they had it when I was in law school. I would have loved to have done it, but it's available. And yes, you're getting law students, but there is a licensed attorney checking their work, making sure, and you'll both be learning, but it is another asset that's out there for you to go on. So now we're going to talk about some of the more basic tools that we've got. We'll try to not make this last too long. For those of you who want to try to do it by yourselves without any assistance, we've actually made available a template for an appeal brief to be filed. We'll go back to the appeal process. After you file your notice of appeal, you have to file an appeal brief. And that's where you present the legal and technical arguments to the board in writing as to why the examiner was wrong. But there's a format and there's specific information that has to be included in the brief as required by the rules, by our rules. So to help you with that, we've created a Word template that you can use, your lawyer can use. And so even if you're represented by counsel, this would be a nice thing to look at because you can see what information your lawyer needs to be putting in that brief. You'd be surprised how often briefs get turned back because they've forgotten to put something in that's part of the rules. This lays out every piece that has to be in there, and you can sit down with your lawyer and said, make sure that everything is in there, even if you've got counsel. There's also an instruction page that goes along with it, and there's also a video that talks about how to fill this out. So it's a very powerful tool that's out there if you want to do it yourself, but also even if you have counsel, you can help ghostwrite some of the stuff in here and take it over to him and have him polish it. Again, a way to save some fees. There is an example of what the document looks like. It breaks down. We've talked about, oops, I'm going the wrong way. Apologize. Inventor hour. We also have various programs to help you, webinars that we have during the year. I mentioned the one we have is the PTAB Inventor Hour. It's a monthly program, although we're taking a hiatus for November and December because it's usually held at the end of the month, much like your meetings are. And we like to have the holidays too. So we're not going to have a December and November program, but they'll have judges or people within the office talking about various aspects of both ex parte appeals and the validity challenges, the AIA trials. We'll talk about nuts and bolts issues. We'll talk about how you address some legal arguments, how to make your arguments convincing to a judge. And a lot of times we'll bring people in from different resources within the patent office or elsewhere to talk about programs that are available to you. For example, this will be our second program on law school clinic programs. Stacey gave a program on the PTAB pro bono program, all the different aspects that are out there, inventor groups, the PTRCs, and they're all recorded and they can be found on the PTO website. You can go back and look at them. They're not very well indexed right now, but we are working on trying to do a subject matter index for them to make them more accessible to you. But most of these are very, very high level and very rudimentary explanation of each of these different aspects of patent law. For those of you who really want to get deep dive into a particular topic, we have the next program, which is called the PTAB Boardside Chats. This again is a monthly, sometimes bi-monthly program. It's really designed more for attorneys and patent agents, but everyone is welcome to listen to it. And they will focus on one specific topic and go into it in great depth. So it might be about novelty arguments, or it might be about obviousness rejections, or some aspect of AIA trials. The whole hour will be devoted to that. Whereas in the inventor hour, we'll cover 3 or 4 different topics in that hour. Again, they're recorded and they are available on the PTO website if you want to go back and look at them. But again, they're not particularly well indexed, so you might have to sort of read through the summaries and see if it's interesting to you. Internally, we have a PTAB webpage. This is our sort of our homepage. It's called New to PTAB. For people, it's their first time coming before us. They can get some general information about who we are, how we work, links to other areas within our website. We've also taken this webpage and translated it into at least a dozen different languages, including Spanish, German, French, Hebrew, and actually we were actually fortunate, with the exception I think of Japanese. We have judges who were fluent in all those languages who were able to do the translation for us, and I think we're the first part of the PTO to actually offer a page and translate it into all those different languages. When you go to the page, I don't show it here, but there'll be a button that it'll let you pick the translations that you can go for, and at least the basic information about PTAB will be available in all those different languages.
At this point, Spanish and German are the only 2 that are up right now, but the other ones will be going live, I would say, in the near term.
Yeah, I think we're trying to work out the translations have all been done. I think we're just trying to figure out how to link them on that page.
Very cool.
There is also in the PTO webpage an inventor and entrepreneur page for those of you who may not have seen it yet. It has ties to a lot of the things we've talked about today, but also other resources in the PTO for inventors. And lastly, we have an annual conference called Invention Con The last one was this past August. This was actually from 2 years ago. One of the highlights, at least for PTAB, as I mentioned, was we had an interview with two inventors from Australia, from Tasmania, actually, about their invention, which is an improvement in raising oysters, which actually I found pretty interesting, but how they were able to appeal by themselves quite successfully and got their patent. So, and that recording of that interview is available for those of you who might be interested in it. They're very interesting discussion of their process. Most of their or a lot of difficulties they had were just from the mail delay between trying to get stuff from the U.S. to Australia and all the way out to Tasmania, which gave them very short deadlines. This was before a lot of it happened before the electronic filing systems that we have now. But they had a very successful time before the board, and they've got their patent, and they're very pleased with it. And that's what I have. I'm happy to stay and answer questions for as long as Madeline and Andrew will let us stay online.
Yeah, that'd be great.
I would like to jump in and circle back to the question that was asked for me, so I can make sure I give an answer to that. I dropped a link in the chat, www.uspto.gov/patents/laws/micro-entity-status. I know that's not the easiest link to just remember, but if you go to the USPTO's website and put micro entity into the search box, you'll get to this page. But the question that was asked was whether the 4 previous applications, whether that was provisional or full applications. Provisional applications do not count when trying to figure out the 4 applications prior as to whether you can be a micro entity. So provisional applications in other countries, that's not what's counted. It's for US applications, full applications. And then the rest of the information on being a micro entity is up there too, so you can see the specifics on the financial requirements and such.
Okay.
Great info.
We've got some incredible questions here. That was fantastic, guys.
Yeah, I really learned a lot. I have a couple in mind, Andrew. Do you? I know we're going a little late here, so we won't go too long. But
go ahead. You go first.
Okay, excellent. Let's see. Someone asked. I'm sorry, I'm not seeing your name. I copy and pasted in a different window. For the patent process, is there somewhere to look to see the status of where the application resides, being examined, in appeal, waiting for payment, and who owns the action? Examiner, appeal arbiter, applicant? This seems like very useful information.
There is a system within the patent office to do that. They've changed the name and the format of it recently. It used to be called pair, public pair, and private pair. But if you can log in and see the status of an application, you need to have the application number to be able to search for it. And it will tell you where it's appealing. You can see, in some cases, you can actually see what the last paper was that was filed in the file. So you can look at that and see, scroll down and see, okay, the applicant's filed something, now it's waiting for the examiner, or the examiner just issued an office action, now it's waiting for the applicant to file something. And you can also see all the prior art that's been cited. I mean, all the papers that have been filed, with the exception of patents, will be in the file, but there'll be documents there that'll summarize all the patents that were cited by the examiner, and you can then get copies of that either through our website or some of the free patent services like Pat to PDF that are out there, if you want to read some of that stuff. But yes, there are, I think if you go into the patent office webpage and their patents, you can look for patent application status, I believe is there, what it says, and that'll ask you to enter some information, and you can get into it, see it. As long as it's past the 18-month stage. Recall that patent applications are kept confidential until they hit the publication and or the 18th month point, and then all the records become publicly available. So if it's not your application, you're not going to be able to see the status until it's been pending for at least 18 months.
Okay. Next question is from George Burkhart. He is the president of the San Antonio Inventors group, great guy, super fantastic group. He said so far it has not been mentioned that the USPTO does have a pro se inventors assistant office that helps pro se inventors. And for those of you guys don't know what pro se means, you're filing the patent yourself. And I've heard a lot of positive things about that office too. Can you talk about that a little?
Just that I know that it exists. We've been, I think it was included because I think the status of the office is in flux right now. But yes, it is another valuable tool. Again, you can call and they'll give you guidance to how to file your application, what type of paper to file, and what have you. They cannot give you legal advice. That's probably the distinction between that and, say, the pro bono programs that are there. So they can, like the Inventors Assistance number you can call. It's, again, a group of experienced, usually often retired examiners who come back working part-time. That'll give you guidance as to what you should do next, but they can't really give you any concrete legal advice.
Right.
We also have a patent ombudsman's office as well. That's a word that trips me up from time to time. So if you go to our USPTO website and search for the Ombuds office, that's another resource to have someone there that can help you through the process. We have a lot of people out here that are just trying to help you shepherd you through the process, because we know it can be a bit of a maze if you don't know what's coming. And if we feel like if we can give you some information, we can help you get through it.
Yeah, and one of the things originally we were calling this the Pro Se Inventor organization or committee within PTAB, but I think we're going to realize that our charter is now going to be much broader than it was, and we're actually, I'm trying to think what the term is that the director is using right now, but the underrepresented people within the organization, we're going to try to open up and make sure that it's not just the independent inventor or the person appearing pro se, but that it's everybody who needs help and how to come to the patent office and work with us to get your patents, because we really want you to have those patents. We want you to have the best patents you can get, and that's really what's going on. It's not to say never. I mean, I will confess there are probably some examiners who take that attitude, but the attitude in the office is we want you to have these patents, even with the board. We want to make sure the patent you get is the best that can be done, and sometimes it's a trying process, and I realize it's expensive, but stick with it. If you really got something that's you think is worth it, it will be worth it at the end.
This one's
Thank you, John.
I have two inventors in my lineage, so I understand the value. I understand the frustration and trying to get it. So
this one's super easy and quick because I'm guessing it's no. Could pro bono be considered for foreign applicants? And my guess is it's for U.S. citizens, but I don't know.
It's for people domiciled in the U.S., so living in the U.S., so not necessarily a citizenship question.
Oh, got it. Living in the U.S. Okay, good. That's good clarification. Maddie, do you have one?
I just wanted to thank John and Stacey for what you just said, which is the acknowledgement that this process is really quite complicated, and there's a lot of paperwork, and there's a lot of legalese, and there's a lot of avenues. And as someone who's been writing about inventors, not necessarily patents, for 15 years, but you can't spend too much time talking about inventors before you're talking about patents. I'm learning something new every time, and I just sense that there's so much that inventors depend on their representatives, their agents, or their attorneys to kind of just know that stuff for them or do it for them. And I see this gap of confusion and fear and just uncertainty that evolves. And so to hear you from the USPTO being very clear and recognizing that, and particularly since Director Vidal has been in charge, it seems like people are going above and beyond to make that really clear, even clearer. The resources that are there, there's an effort to make them more known. And I just want to recognize that. I feel like we need to have you all back as soon as possible, because we can't get to all of the questions that are here because there are a lot of them. And I don't want to go too much longer. Andrew, there wasn't necessarily one question I saw that we had to answer tonight, but I would like to encourage everyone to please, while we have these last couple of minutes, if you would thank
Yeah.
Judge Schneider and Judge White for coming on. And if you enjoyed this presentation, if you want to see more information from the USPTO, if this had value, please thank them in a comment. We'll be following up and sharing that with them. And I'm also going to retain your questions and use this as a guide and either get the answers from them or someone else who can help.
Happy to.
Yeah, we want to hear those questions. I know they do. That's why they're here. That's why we planned this. So I'm just so appreciative.
While everybody's typing in their thanks, let's do a group shot. So it only takes a few seconds here. So everybody like gives a thumbs up or a wave and a smile. And I'm always busy doing this, so then I'm not. Here we go.
Yeah.
Hold on, that didn't work, guys. Hold on. You guys are gonna get sore arms here. Command Shift 3. There we go. Okay, I got it. Okay, keep thumbs up, keep the smiles. Let's try it one more time here, guys. Okay, here we go. One more time.
Thank you, everybody.
All right, now let me go to the next page, and then there's almost nobody on the second page, so I think we're good there. All right, thanks for being patient with me there, guys.
You know, one of the resources that we don't talk about because it's very lengthy, very voluminous. But if you're trying to understand what the examiner is saying, there is what's called the Manual of Patent Examining Procedure. It is Stacey, I don't have my paper copy.
I'm like, I have one right behind me.
But it is available online. It is available online, and it's got everything the examiner does.
Wow.
Everything the examiner does is in that book. And
so that's a pretty big book.
But he'll quite often, the examiner will quite often reference a section in the MPEP. And so you're trying to figure out what he's talking about. You can see the full text because he might just give you a snippet. You want to really see
the
what
whole
the
thing's
section
available
is about
electronically.
Oh, that's what I was going to ask. That was my question.
That visual, thank you for sharing the physical book though, because that really leaves an impression. There's a lot to learn.
Well, it also has the patent statute.
That's why we look at it and we say that you can be a highly intelligent person. You can be a PhD. You can be anybody and still get lost in some of these regulations. It's not a matter of, you couldn't understand. Nobody necessarily told you, and it's not something that's necessarily intuitive. And
Totally.
We want to provide some resources to make that easier to navigate, because we know that it's not something that you're necessarily just gonna, oh, of course I should have known that.
So if somebody's working with their attorney and the examiner's referencing something, they could go to your site and in the search bar type in, what would they type in to find this ridiculously huge manual?
It's all nicely indexed, and you can click the particular section, and it breaks down even by every subsection. So the examiner says, I'm citing the MP 608.3.2.1. You type that in, and it'll pop up, and then you'll see exactly what he's talking about.
Okay.
So,
the whole thing is on the website.
It's all on the PTO website.
There's always something more to learn.
It's much easier. I mean,
almost everybody's going to have a patent attorney. It's nice for the inventor to be more knowledgeable, so they make sure their patent attorney is doing everything right, stay in the process. So many inventors step away from the process because of how complicated it is, and I think that's a mistake. I think they should stay involved as they can in the process. Not get in the way, but stay involved.
Yeah. And also, to be honest with you, it'll help you save you some money in the long run, because you can spend some time explaining. Take the time to read the Schmedlab patent that's been handed to you. I'm sorry, that's the name I use. And you spend some time, and know your invention better than your lawyer does. So what's the difference between what's described in Schmedlab and what you've actually got sitting on your desk? What's the difference between that clip that you've designed for hair that's different than what the other person has, or whatever the invention might be? That by heart. You made it. That's just your baby. You need to spend the time with your attorney and tell him, and really spend some time looking over these things when he gives you these references, and be able to sit down with him and help him. I mean, that was something I always, relied upon even when I was at Exxon. I would go back to the scientists and said, okay, this is what he's got. What's the difference between sometimes it's even their own patent. What's the difference between what you did 40 years ago and what you're doing now? I mean, or, that type of thing. So it's there, help your attorney, don't get discouraged. And there are lots of resources out there. And one of the things we would like to hear from you is, what other resources can we make available to you? And if they're possible, we'll do it. I mean, that's how we created a lot of what you see here today. Was about 2 years ago, a group from the PTAB met with Stephen Key and some of the other inventor groups around the country and got feedback from them and said, what can we do to help your members? And so we created the assets we did. We're now coming back around and tell you what we've done, but we're not done. You tell us we don't want something else we can do or make things better. We're happy to consider it. If we can do it, we'll do it.
I
That is
ran
awesome.
I've run my other business, InventRight, for 23 years, been doing IGA for 5 or 6, ran an inventors group for 14. And I can say, so I've been observing what the patent office has been doing or not doing. You guys are doing a better job than ever with regards to helping independent inventors. So thank you so much for listening and for making these changes. And also for saying we're open to making even more. That's fantastic. Because to be honest, we're a small percentage of everybody that files patents. So for you guys to be paying so much attention to us, independent inventors, that really means a lot. So thank you.
Yeah.
We're glad to do it. We're glad to be here to help.
Yeah. Madeline, thank you for setting John and Stacey up. You guys did a fantastic job. And I just want to remind everybody to take care and keep inventing and have a great evening.
Thank you for having us.
See you all
Thank
soon.
you.
Bye.
Bye, everybody.
Bye.